And there's a video I recorded, but I didn't publish it because it just didn't sit right, or as new information came out that kind of invalidated it. So I was like, no, I'm gonna sit on this one. I'm gonna sit this one out. Um, the issue with the DMCA is not that it needs to be dismantled. Like in particular, I'm gonna cover Section 230. So I'm not sure what Lewis's video is actually going to be talking about. The issue is case law. Let me explain. Alright. Third time's the charm to explain this. Just to get that intro shot right. There's already case precedent for, in the context of it was Pepsi, lost a lawsuit, quite rightly, when a photo was taken when there was like a murder or some riot. I think it was during the LA riots. Because a billboard they had paid for was in the background of some of the damage and whatnot. They just didn't want to be associated with that. Which, to be fair, no one wants to be associated to a tragedy. However, you paid for the billboard slot and you can't control, nor do you have the right to control, what basically happens in view of that billboard, which was more or less that 200 read of that court ruling. That applying to YouTube and ad placement overall will really give back financial protection to YouTube, etc., and Twitch, because they have kind of needed it for quite some time. Because like in particular, YouTube doesn't make a lot of money. I think it's only recently that it's actually made money. But that's just one bit of case law that should be carried over to the internet overall, because it's a privately owned, largely the website hosts, being YouTube or Twitch or Gmail or some blog post. The established terms that gets used when you make an article on your blog, for example, that it was like no different than an article in the newspaper, it's just on a private publication. Those rules should apply. You, the website host, be it like WordPress or Medium, assume, although Medium's like guest article circumstance is a bit more of a formal publication. Just as an example, those should be treated no different than their physical medium variant. It's just the communication method your transmission method is the internet. It's going to cause some problems, and there's, going to be some issues with where that goes, but overall it'll be much healthier for the internet. For example, YouTube won't be able to censor things or demonetize things because it is not brand safe or safe content, even though this is talking about history. Or it's firearms related content that could be put on TV through the old ways with zero issues, like Discovery Channel and whatnot in like the early 2000s. Like that content should still be fully monetizable if it is, according to the various doesn't violate any of the FCC rules for what you are or are not allowed to put on broadcast television for the given time slot it was initially published in. So premiering content will be your anchor point for how it's measured. So there's going to be a lot of content that will get premiered in the wrong time slot. It's like, cool, this is the wrong time slot, you can get demonetized for this. Good luck. Based off of the time slot of the individual's primary residence. So if you're traveling, tough tits. That's a you problem. You just offset the upload. Although live broadcasts, well, again, that's a different set of rules. The internet, the method of transmission is the internet. No different than the radio wave with the method of transmission for AM, FM radio, as well as UHF, VHF television. Literally, there's no difference in this. It's just you're using technology stacked on top of each other. of course, I'm referencing the analog TV days, and later the digital days through like cable boxes, etc. But it's just getting, once that happens, I am specifically targeting monetization because it kind of will put guardrails on a lot of things as for what the platform, or rather the website host, can monetize versus what they can't, and also what they can remove you for versus what they can't. Because if it's compliant to the FCC guidelines, you also cannot ban or that user for something that is compliant with the FCC guidelines, because it is perfectly legal content. That's the key. You're now taking away, you're now also, not just monetization, but also the bans, you're also taking away a lot of power they have over what content does or doesn't get published. That does mean there's going to be a bit of garbage going through, and the FCC is going to be in an interesting position, because if it's not FCC safe, but it is safe for the general internet to have, realistically speaking, it's no longer the FCC's wheelhouse beyond the technological side, because you can look at a Wi-Fi module and it says FCC compliant on it, because it's still transmitting radio waves, and that's the FCC's legal regulatory domain. Same with a lot of the Wi-Fi spec as well. There's some stuff that the FCC does regarding regulatory compliance. So whenever Wi-Fi, like the Wi-Fi 7 or whatever, there was they had to reserve some bands, and also figure out with different regulatory agencies, okay, what bands are available that we can use that don't step on other radio bands. So it's a whole thing. But here we are. That's that. That's really it. There's not much else to say there, because once that established case law and established method is in play, a lot of existing regulatory infrastructure that the general public is both used to and expects, but for whatever reason fucking doesn't get, because magically it is the internet. It magically makes it something different, even though it's just a means of communication. That is fundamentally what the internet is. No different than sending a letter or radio waves. Well, literally sending radio waves is one method, or pigeon, internet by pigeon, or file transfer via pigeon. That one South Korean ISP really getting shamed today. Yeah. Yes, it shifts the bar to a government agency doing it, but clearly letting the website hosts, the platforms, their website hosts, do that kind of regulation has not done that well, and it has ultimately harmed the internet more than it's helped. Here in Canada, it's not going to do a whole lot. Any regulation we do, just like with the link text that happened, the internet's one hell of a thing to be a market equalizer in terms of actual market power. Canada don't have much. Most of our economy is in the financial sector anyway, so yay! House of Cards! That covers it, actually. So, so actually further, so when it comes to things like, say, Twitch, you're dealing with live broadcast environment for all of it. It's not pre-recorded content like with what you expect with YouTube, with premiering content, or that's a big thing where you have promotions and stuff for the pre-recorded content, like say like a straight-to-TV movie, for example, may have those kinds of ads running, where that would be under that kind of guidelines. So it's like, what time slot was it initially premiered or otherwise made public? Because something that's unlisted or private should not be considered as part of these rules. Because it's unlisted video, it's a private video, it's not meant for public consumption. So the FCC rules regarding what is legally broadcast safe and what is not don't apply. But also, now another thing as well that should be added is you cannot retroactively enforce rules, as well any changes to policy. So anything that does not conflict with FCC rules as effectively being your baseline is fine. But if there is a conflict between FCC rules and YouTube policy or Twitch or Twitter or whatever policy, FCC rules have the seniority here. Yes, it does mean that people have to pay attention to the politics of the situation, but again, you'd have to make a regulatory change, so that any policy changes cannot be retroactively enforced without it going through a judicial check that the FCC has to specifically apply for. And relevant parties whose content would be directly affected, they have legal representation in that fight. The FCC has to give them proper notice and allow them their representation. It's effectively, the FCC would have to propose that rule change, that would retroactively target some content, and any and all individuals would enter into a class by default against the FCC, saying, hey, this is and going through that legal process. That, again, the FCC would be initiating against those individuals as a sort of preemptive method. But the FCC is the one who's the out-of-pocket for the initial filing stuff. Yeah. That's one way of doing it. Something in that ballpark. I'm not kind of the right regulations. I'm a high school dropout, working in a warehouse job with a very high reading comprehension. Yeah, I'm just gonna slap this onto the end of whatever I just recorded earlier because I had some other stuff that didn't work out because I kept getting distracted. There's also hoping the audio isn't ass in this echoey room. Like and subscribe, I guess. I don't know. I'm not your boss.